The papers arrived on a Thursday. 14 pages tabbed and notarized, delivered by a courier who waited at the door with the particular neutrality of someone paid not to register what they are carrying. I brought them inside, set them on the kitchen table beside my coffee, and read every page. Then I signed every line that required my signature, initialed every page that required an initial, and handed the stack back to the courier with a smile he clearly had not expected. My attorney called 40 minutes later. She had heard from opposing counsel. She said, "They are confused. They thought you would push back on the asset division." I said, "I know they did." She was quiet for a moment. Then she said, "Simone, I need you to tell me what you know that they don't." I said, "Give it 6 weeks. By then the judge will have opened the file." What was in that file had been sitting in the Fulton County court system for 11 months. Nobody on the other side had looked for it because nobody on the other side had imagined it existed. That was the most expensive assumption Marcus Vane's attorneys ever made on his behalf. And when the judge opened it on a Tuesday morning in a courtroom on Pryor Street in downtown Atlanta, what had looked like a clean, cooperative, uncontested divorce became something else entirely. A proceeding whose outcome had been determined not in that courtroom, not in any negotiation, but in a property records office on a Wednesday afternoon 4 years earlier, when I had filed a document that took 11 minutes to process and cost me $47. My name is Renata Osei Mensah. I am 44 years old. I grew up in Stone Mountain, Georgia, the second of 4 children. My father drove a MARTA bus route through DeKalb County for 22 years and coached youth football on Saturday mornings at Redan Park. My mother worked as a medical billing specialist for a large orthopedic group in Tucker, and she brought the same methodical clarity she applied to insurance codes and denial appeals to every financial decision our family made. She kept a 3-ring binder, the kind with the clear plastic sleeve on the cover, dark green, letter-sized, in the kitchen cabinet beside the stove, and in it she kept every document that mattered. The mortgage statement, the insurance declarations pages, the car titles, the household budget updated in pencil every 2 weeks, and a running log she called the property record, which was simply a handwritten list of every asset the family held, its current estimated value, and the location of its documentation. She said 2 things to me about that binder that I have never forgotten. The first, everything you own should be findable in under 3 minutes. The second, if you cannot prove you have it, assume someone will eventually claim you don't. I have never been able to improve on either of those sentences. They are the entire foundation of what happened in that courtroom on Pryor Street. I graduated from Georgia State University in 2002 with a degree in finance. I went directly into a property management company in Buckhead as a junior analyst, spent 3 years learning how commercial and residential real estate assets are structured, financed, and documented, and was promoted twice before I left in 2005 to join a mid-sized real estate development firm in Midtown Atlanta. I spent 6 years there. I underwrote acquisition deals, managed due diligence processes, and developed an understanding of title records, deed structures, and property documentation so thorough that by 2010 I could read a chain of title the way a physician reads a scan, not just the surface information but the gaps, the anomalies, the things that should be there and aren't. In 2011 I left to build something for myself, not immediately and not all at once. I spent 18 months doing consulting work for smaller real estate operators in the Atlanta metro, reviewing acquisition targets, preparing investor reports, running financial models. I kept every engagement formal, signed agreement letters on letterhead, separate business checking account at Regions Bank opened in September 2011 in the name of Osei Mensah Property Advisors LLC, every invoice issued from QuickBooks, every payment deposited into that account alone. I registered the LLC with the Georgia Secretary of State in August 2011. I obtained my Georgia real estate license in October 2011. The office was my spare bedroom in a rented apartment in East Atlanta, but the paperwork was immaculate. By the end of 2012 I had 4 ongoing consulting clients, $78,000 in annual revenue, and a clear picture of what I actually wanted to build, not a consulting practice but a property holdings company. I wanted to own things. I had spent 11 years helping other people assess and acquire real estate, and I understood, with the precision of someone who had run the numbers across hundreds of deals, exactly what kind of asset produced durable, compounding returns in the Atlanta market. I wanted small multifamily properties, 2 to 8 units in transitional neighborhoods close to job centers and transit corridors. I wanted to buy them undervalued, improve them strategically, and hold them for income. Not for a flip, for permanent cash-flowing ownership. In February of 2013 I purchased my first property, a 4-unit building on Memorial Drive in the Edgewood neighborhood of Atlanta. The purchase price was $112,000. I put $22,000 down from my personal savings, money I had accumulated across 6 years of disciplined monthly transfers into a Marcus by Goldman Sachs high-yield savings account, documented in monthly statements I had retained since 2007. The mortgage was through Synovus Bank in my name alone. The deed was recorded with Fulton County in my name alone under the LLC. I kept a copy of the recorded deed in a Pendaflex hanging folder labeled Edgewood Memorial in the dark green binder I had inherited spiritually and operationally from my mother. I want to pause there for a moment because that binder matters more than anything that follows. I had been keeping my version of my mother's binder since I was 26 years old, not as a legal precaution, not as divorce preparation. as the simple operational habit of a person who understood from watching her mother that the difference between an asset and a claim is documentation. I kept it the way a serious cook keeps a mise en place, not because something is about to go wrong, but because the preparation is what makes everything go right when it counts. By February of 2013, that binder contained my Georgia LLC registration, my Georgia real estate license, my Regions Bank business account opening documents, my QuickBooks export of every business transaction from September 2011 through the prior month, and a property log with every deal I had ever evaluated, the ones I had passed on and why, the ones I intended to pursue, the ones I owned. Every document dated, every document in its tab. The Edgewood property was the first entry on the ownership page. I met Marcus Vane in the late spring of 2014 at a real estate investment networking event at the Loudermilk Conference Center in Midtown. He was 38, worked in commercial lending at a regional bank, and carried himself with the practiced warmth of someone who had spent 15 years building relationships as a professional instrument. He was attentive in the way that people who have learned to be attentive are attentive. It was real, but it was also technique, and I recognized both qualities simultaneously and did not find either one disqualifying. He asked good questions. He listened to the answers. He remembered specific things I had said when we spoke again 3 weeks later at a follow-up event, and that quality of attention, the ability to retain what you've been told and demonstrate that retention, is something I have always found genuinely compelling. We dated for 10 months. He knew from our third conversation that I owned real estate. He knew I had an LLC. He knew I had a property on Memorial Drive. What he did not know, what I had no reason to tell him, and no occasion to tell him in the natural course of 10 months of dating, was the precise documentation structure of everything I held, or the acquisition pace I was building toward, or the way the binder in my kitchen cabinet was organized. Those were operational facts, not relationship ones, and I have never confused those two categories. We were engaged in April of 2015. I added a second property, a 6-unit building in Kirkwood, purchased for $188,000 through Banner Bank, deed recorded in Fulton County in the LLC's name 2 weeks before the engagement dinner. I mention this not because the timing was strategic, but because it was simply the timeline. The deal had been under contract for 60 days. It closed when it closed. I want to be precise about what I did and did not do in the period between the engagement and the wedding, because that precision is where the story actually lives. I did not consult an attorney about protecting the properties from a potential future divorce. Not because I was naive about the possibility. I was 35 years old and had read enough about marital asset law to understand the basic framework, but because the protection was already built into the structure I had been maintaining for 4 years. The LLC held the properties. The LLC predated the relationship by 3 years. Every mortgage was in the LLC's name. Every deed was in the LLC's name. Every bank account was in the LLC's name. The LLC's operating agreement named me as sole member. I had done nothing to intertwine those assets with Marcus's finances at any point in the relationship, not because I was building a wall, but because clean separation between personal and business finances was simply how I operated. It was how I had always operated. It was not a defensive posture, it was just accuracy. We married in September of 2015 at a venue in Decatur, 140 guests. My mother sat in the second row and wore the same composed, watchful expression she wears whenever she is observing something important unfold and reserves her judgment for after. The first 2 years of the marriage were genuinely what they appeared to be. Marcus was a careful and considerate partner in the ways that matter for daily life. He cooked on weekends with the specificity of someone who had taken it seriously since his 20s, mise en place on the counter, timers set, the kind of attention to process that I recognized and respected. We had the ease of two professionally organized people who do not generate unnecessary friction about how the household runs. I was buying and improving properties. He was advancing at the bank. The shared expenses were covered, tracked in a Google Sheets file I updated every Sunday, and never a source of conflict. By the end of 2016, Osai Mensa Property Advisors held 5 properties. The original Edgewood 4-unit, the Kirkwood 6-unit, a duplex in Reynoldstown I had acquired in early 2015 before the engagement, a 3-unit building in East Point acquired in the third quarter of 2016, and a single-family rental in Avondale Estates that I had picked up at auction through the Shelby County Tax Commissioner's office in October 2016 for $61,000. A transaction so clean and so well documented in the auction record, and the subsequent county deed filing, that it became, years later, one of the 5 exhibits my attorney used to demonstrate the portfolio's character. I hired my first full-time employee in January of 2017, a property operations manager named Deidre, who had spent 8 years working for a large residential management company in Atlanta and who brought a systems discipline I recognized immediately as the kind that compounds over time. We moved the business out of the East Atlanta apartment and into a dedicated office suite in a professional building on Ponce de Leon Avenue. I signed the lease in the LLC's name. I opened a second business account at Wells Fargo alongside the region's operating account, a reserve account for capital expenditure and maintenance, funded by a percentage of each month's rental income, documented in the QuickBooks chart of accounts under a category I had labeled CapEx Reserve since 2013. At home, Marcus and I had a rhythm that functioned. I want to say that clearly and without qualification. The marriage was not a performance or a holding pattern. It was a genuine shared life in the ways that genuine shared lives are actually constituted, the specific quality of quiet on Sunday mornings, the running jokes whose origins both people remember, the small accumulated knowledge of another person's habits and preferences that is different in texture from any other kind of knowledge. I did not spend those years waiting for something to go wrong. I spent them building two things simultaneously, the portfolio and the marriage, with the reasonable expectation that both would continue. By the close of 2017, the portfolio had 6 properties, 41 rental units across 4 Atlanta area neighborhoods, and annual net operating income of $308,000. I had a full-year QuickBooks export. I had a Regions Bank annual statement and a Wells Fargo annual statement showing every transaction in both accounts. I had app payroll records for Daedra and for the part-time bookkeeper I had brought on in September. I had 12 months of Buildium property management software records, every maintenance request, every rent payment, every lease renewal organized by property and exportable to PDF. And I had the dark green binder, now supplemented by a second binder for overflow, with a recorded deed for every property in its labeled tab. The third year of the marriage was when the friction that had been entirely absent in years 1 and 2 began to appear quietly and without announcement, the way structural shifts in a building first express themselves not as visible damage but as sounds you cannot immediately source. Marcus had a difficult year professionally in 2017. A reorganization at his bank resulted in a change in his reporting structure that reduced his autonomy in ways he found genuinely frustrating, and his income, which had been higher than mine for the first 2 years of our marriage, became roughly equivalent to mine as the portfolio's distributions grew. I do not think this equivalence was the cause of what shifted in him. I think it was a contributing condition that clarified something that had been latent. He began in the second half of 2017 to speak about the portfolio in ways that were subtly but distinctly different from how he had spoken about it before. Not hostile, not overt, the shift was in the grammar of it, from your properties to the properties, from your business to what we've built. He said it at a dinner with friends in October of 2017, referring to what we've built together over the last 2 years. And I noted it the way you note a small discrepancy in a financial statement without immediate alarm but with the attention that tells you to check the supporting documentation. I mentioned it to my mother the following Sunday on the phone. She asked 3 questions. Is his name on any deed? No. Is his name on any bank account? No. Has any joint money ever gone into a property acquisition? No, not once, she said. Then he is describing a history that does not match the record. Keep the record clean. I said, I know. She said, I know you know. I'm saying it anyway. I did not argue with Marcus about the grammar shift. I noted each instance of it: the dinner in October, a conversation with his brother in December, a casual remark at a New Year's event, and I filed them the way you file variance reports, not to use immediately but to have available if the pattern develops into something that requires documentation. I did not mention the binder. I did not describe the LLC's operating structure in any detail. I said when asked that the business was doing well. I continued to update the binder every time a lease was signed, a deed was recorded, or an account statement closed. In the first quarter of 2018, I acquired 2 more properties. A 7-unit building in the West End neighborhood of Atlanta for $243,000 through a Synovus commercial loan in the LLC's name, and a single-family rental in College Park for $89,000, purchased with LLC retained earnings, cash, no mortgage, from the Wells Fargo Capital Reserve account. The College Park acquisition was the first property I had purchased entirely with money the LLC had generated itself, retained inside the LLC and deployed as LLC capital. The deed was recorded in Fulton County in February of 2018. That filing cost $47 and took 11 minutes at the window in the Fulton County Records office on Pryor Street. I remember the exact figures because I wrote them in the binder that evening. $47 recording fee. 11 minutes, Fulton County Superior Court Clerk. Deed Book 56,782, page 214. At no point in the acquisition of any of these 8 properties had Marcus Vane contributed capital, cautioned a mortgage, guaranteed a loan, signed an operating agreement, appeared on a title, or been named in any instrument associated with the LLC or any of its holdings. This was not calculation on my part. It was simply the documentation record of what had actually occurred. Documentation is not strategy, it is history written down as it happens. The difference between those two things, between preparation and documentation, is the difference between an accusation and a fact. By the close of 2018, the portfolio had generated sufficient net operating income that I commissioned a formal appraisal of all 8 properties from a certified appraiser at a firm called 10X Realty Valuations, an Atlanta-based commercial appraisal company that specialized in small multifamily and mixed-use residential assets. The process took 5 weeks. The combined appraised value of the 8 properties as of November 2018 was $2,140,000. Against total outstanding mortgage debt of $612,000, the LLC's net asset value, equity in the properties, was $1,528,000. I had the appraisal bound in a plastic report cover and placed it in the overflow binder behind a tab labeled Portfolio Valuation, NOV 2018. I did not show it to Marcus, I did not describe its contents, I placed it in the binder and I went and made coffee. The marriage did not end dramatically. I want to say this clearly because the story that follows should not be understood as the story of a relationship that was always heading toward damage. It was not. What happened was the slower kind of ending, the kind that arrives not as a rupture but as a progressive and irreversible divergence between what two people are building and where they understand themselves to be building it. By late 2019, Marcus and I were living together with a quality of mutual accommodation that was civil, functional, and no longer the foundation of anything growing. We were, in the plainest terms, two people sharing a house without any longer sharing a direction. In January of 2020, I told him I thought we should separate. We were in the kitchen. It was a Sunday evening, winter, the particular flat grey light of January in Atlanta that is not cold enough to be dramatic and not warm enough to be comfortable. I said what I had to say plainly. I did not believe we were building toward the same thing anymore, and I thought continuing to share a household was delaying a reckoning we were both already aware of. He was quiet for a long time. Then he said the portfolio, 2 words, and in those 2 words was the entire architecture of the 18 months preceding them. Not a husband absorbing the dissolution of a marriage, a person assessing a position. What those 2 words communicated with more clarity than any subsequent legal filing would achieve was that the period of the marriage during which he had been quietly recategorizing what I owned as something we had built had not been casual speech. It had been orientation. He had been finding out where he stood. I said, I would like you to take some time this week and think about what a fair separation looks like. He said, my attorney will be in touch. I called Adiz Nwasu the following morning. Adiz had been my property attorney since 2013, the one who had reviewed my original LLC operating agreement and every acquisition since. She had the quality of counsel that makes opposing attorneys recalibrate their assumptions simply upon learning she is involved. I described what I had observed across the preceding 2 years, the grammar shift, the dinner remark, the pattern. She listened without interrupting. Then she said, tell me what's in the binder. I told her. She was quiet for a moment. Then she said, Renata, I want you to bring me the binder. I brought it to her office on a Wednesday. She went through it tab by tab. It took 1 hour and 20 minutes. At the end, she set it on her desk and sat back and looked at me. She said, I have been practicing real estate and family law in Atlanta for 17 years. I have never seen a client walk in with documentation this complete, this chronologically organized, and this structurally clean. I said, my mother kept a binder. She said, tell your mother she may have just saved you $1.5 million. Marcus's attorney filed a claim asserting that the real property portfolio, or a substantial portion of it, constituted a marital asset subject to equitable distribution. The theory was what family law practitioners call commingling and marital contribution, the argument that a spouse's financial support and domestic contribution during the marriage had materially enabled the appreciation and expansion of the portfolio, such that the marriage itself had generated value in the assets that now entitled Marcus to a share of the equity. It is not a frivolous argument in the abstract. It has succeeded in cases where the factual record is ambiguous, where joint funds went toward property costs, where a spouse was listed on a deed for any period, where business accounts received transfers from household accounts, where documentation gaps allow a narrative to fill the space that facts leave open. Osai Mensa Property Advisors LLC had no documentation gaps. The filing included 5 specific claims: that Marcus had contributed to mortgage payments on the portfolio's properties, that his income had freed the LLC to reinvest profits rather than support household expenses, that he had participated in property management decisions, that his professional network had facilitated at least 1 acquisition, and that the portfolio's appreciation during the marriage years constituted marital equity. Adiz responded to each claim in sequence at the first hearing, document by document, account statement by account statement. The mortgage claim: every mortgage in the portfolio was held by the LLC and serviced exclusively from the Regions Bank LLC operating account. The Regions Bank statements for every month from September 2011 through the date of separation showed not 1 transfer from any joint account, not 1 payment from any account connected to Marcus Vane in any capacity. The statements were printed, organized chronologically, and submitted as Exhibit A. 102 months of statements, not 1 exception. The household income claimed that his earnings had freed LLC profits to reinvest. The Google Sheets household budget I had maintained since January of 2016, updated every Sunday, showing that household expenses including the mortgage on the marital home, utilities, groceries, and all joint expenditures had been covered 63% by my personal distributions from the LLC and 37% by Marcus's income. The LLC had not depended on his household contribution to reinvest. The household had been majority funded by the LLC's distributions from the beginning of the marriage. That spreadsheet was submitted as Exhibit B, every cell timestamped, every figure traceable to a bank statement. The property management claim: the Buildium property management records showed every maintenance decision, every tenant communication, every vendor authorization. Every item was initiated and approved under Daedra's access credentials or mine. Marcus's name appeared in the Buildium system 0 times across every operational record for every property across every year. The Bildium export was submitted as Exhibit C. The professional network claimed that he had facilitated an acquisition through his lending connections. Adiz asked opposing counsel to identify which acquisition. They named the West End 7 unit acquired in 2018. Adiz produced the complete loan file from Synovus Bank for that transaction, including the loan application, the underwriting documents, and the closing disclosure. The loan had been underwritten entirely on the LLC's financial profile, the portfolio's operating history, the LLC's net operating income, and my personal credit. Marcus Vane's name appeared nowhere in the loan file, not as a reference, not as a guarantor, not in any capacity. The Synovus loan file was submitted as Exhibit D, the marital appreciation claim, that the portfolio's growth during the marriage years constituted marital equity. Adiz submitted the 10x Realty Valuations appraisal from November of 2018, establishing the portfolio's combined appraised value at $2,140,000, against which she placed the recorded deed dates and purchase prices for every property acquired before the marriage began in September of 2015. Of the 8 properties in the portfolio at the time of separation, 6 had been acquired before the wedding. 2 had been acquired during the marriage, the West End 7 unit and the College Park single family. The West End property was mortgaged through Synovus at a loan-to-value ratio that left minimal equity at acquisition. The College Park property had been purchased with LLC retained earnings, cash generated entirely by properties that predated the marriage. The 10x appraisal, cross-referenced with the deed recording dates, demonstrated that the overwhelming majority of the portfolio's equity had been created by premarital acquisitions and premarital capital. The marital period's contribution to the portfolio's net asset value on the documentation available was not material to the LLC's overall position. That was Exhibit E, and then Adiz opened the file. Not the binder, the file she had submitted to the Fulton County Superior Court Clerk's office 11 months earlier, at the beginning of the proceeding, which had been sitting in the court record, accessible to any party who looked for it for the duration of the discovery period. Marcus's attorneys had not looked for it. They had not imagined it existed because they had not imagined there was anything in the Fulton County records that their client had not described to them. What was in the file was a certified copy of the Osai Mensa Property Advisors LLC operating agreement, the original filed with the Georgia Secretary of State in August of 2011, along with every amendment to that agreement through the date of separation. The operating agreement had been amended twice, once in 2014 to update the registered agent address and once in 2016 to formalize Daedra's operational role as a non-member manager with defined responsibilities and no ownership interest. The operating agreement named one member, one owner, one person with any interest, any equity, any entitlement in the LLC or any asset it held. Every amendment confirmed the same. That operating agreement had been on file in the Fulton County Superior Court Clerk's office since Adiz had submitted it as a precautionary filing 11 months earlier. A standard procedure she described to me as, we put the founding document into the court's own record so that its date and its contents cannot be disputed, amended, or characterized as a document produced for litigation purposes. It was not produced for litigation. It predated the litigation by 9 years. It predated the marriage by 4, and it said with the authority of the Georgia Secretary of State's original certification that Marcus Vane had never held any interest in Osai Mensa Property Advisors LLC, that no person other than Renata Osai Mensa had ever held any interest in Osai Mensa Property Advisors LLC, and that the LLC's assets, all of them, belonged entirely to its sole member. The judge read it. He set it down. He looked at opposing counsel for a moment that contained several sentences he did not speak. Then he asked whether the marital contribution claims would be pursued at trial in the face of this documentary record. Opposing counsel requested a recess. The recess lasted 40 minutes. When the parties returned, Marcus's attorney indicated that the marital contribution claims against the real property portfolio would not be advanced. The proceeding was reconfigured around the actual marital assets, the equity in the shared home indicator, which was divided equitably based on documented down payment contributions from both parties, and a joint fidelity brokerage account opened during the marriage divided equally. Both outcomes were appropriate. The portfolio was not part of either outcome because the portfolio had never been a marital asset. It had been built before the marriage, documented throughout the marriage, structured inside an entity whose founding documents were 9 years old and filed with the court's own clerk before the first hearing. By the time opposing counsel finished reviewing Exhibit E and the operating agreement, there was no surface left for any claim to find purchase on. The final order was signed in June of 2021. I was in Adiz's office when her paralegal called with confirmation. I thanked Adiz. She said the documentation did the work. I said the documentation was just the history. She said, I know, that's what made it work. The weeks after the final order were not the relief people imagine when they picture the end of a difficult legal proceeding. There was no surge of triumph. There was the slow unwinding of a specific kind of sustained attention, the awareness that for 17 months I had been running the portfolio, managing the staff, maintaining the client relationships, and handling the legal proceedings simultaneously, keeping each completely insulated from the others so that no client ever knew, no tenant ever knew. No member of the operational team ever felt the weight of what was being adjudicated in a courtroom on Pryor Street while they were doing their work on Ponce de Leon Avenue. I drove home from Adi's office through Atlanta afternoon traffic and sat in the driveway for a few minutes before going inside. I thought about the February morning in 2018 when I had stood at the window of the Fulton County Records office and paid $47 to file a deed for a house in College Park that I had purchased with money my own LLC had generated. I thought about the fact that I had written those numbers in the binder that evening, $47, $11 minutes, deed book 56,782, page 214, not because I had any idea they would matter in a courtroom, but because that was simply how you close a transaction. You record the filing, you write it in the log, you put the copy in the tab. Precision practiced as ordinary procedure. The notebook entry that becomes the exhibit that becomes the fact that no argument can revise. I went inside. I opened the binder to the College Park tab. The deed was there where it had always been. I made coffee. 3 months after the final order, I acquired a 9th property, a 6-unit building in the Westview neighborhood of Atlanta, purchased for $260,000 with a Bank of America commercial loan in the LLC's name, underwritten entirely on the portfolio's 11-year operating history. I signed the loan documents at the closing table and drove directly to the Fulton County Records office and filed the deed the same afternoon. The recording fee was $52. I wrote it in the binder that evening. The timeline of everything, the acquisition, the filing, the entry, contained not one gap, not one ambiguity, not one moment in which a document failed to follow directly and immediately from the transaction it recorded. That is the whole practice. That is what I learned at a kitchen table in Stone Mountain, Georgia, watching a woman update a 3-ring binder in pencil on a Sunday evening while dinner was on the stove and the rest of the household moved around her as if nothing significant was happening. Nothing dramatic was happening, that was the point. The significance was in the habit, not the occasion. A habit practiced consistently enough loses any distinction between ordinary and consequential. It is all ordinary. It is all therefore consequential. Marcus did not contest the final order. By several accounts I did not seek and have not pursued. He has returned to work at a different bank in Atlanta. I hold no position on his trajectory. The end of a marriage does not require the diminishment of the other person to be complete, and I have no interest in a version of this story that is animated by his failure. His trajectory is his, mine is mine. Adi sent me a short email 2 weeks after the final order. She said she had been practicing for 17 years and had handled a significant number of asset protection cases. She said, I have never seen a client for whom the documentation was not preparation, it was simply the way they had always lived. She said that distinction was, in her professional view, the entire reason the outcome had been what it was. She asked if she could describe the approach anonymized without identifying details to other clients. I said, tell them what my mother told me. She asked what that was. I wrote back, everything you own should be findable in under 3 minutes. If you cannot prove you have it, assume someone will eventually claim you don't. She wrote back one word, perfect. 6 months after the final order, my mother came to my house for dinner. She brought food the way she always brings food, and she brought her binder. The original one, dark green clear plastic sleeve on the cover, the same one I had watched her update for the first time when I was 7 years old, and she had explained to me without ceremony that the family kept track of what it had so that no one could ever tell us we had less than we knew we had. After dinner she sat at the kitchen table and updated her household budget for the month in pencil, the way she has always done it: income, fixed expenses, variable expenses, what remains. She did not make a speech, she did not say anything about the preceding 17 months. She sat at the table, opened the binder and kept her numbers. When she was done she closed the binder and looked at me. She said, you kept the record clean. I said, I learned from the record keeper. She smiled, not the watchful expression she wears at consequential moments, but a different one, the kind reserved for confirmation of something known for a long time. She put the binder in her bag and I drove her home to Stone Mountain. That is the moment I returned to, not the hearing room. Not Exhibit E, not the 40-minute recess or the moment opposing counsel abandoned the portfolio claims or the final order signed on a Tuesday in June. The moment at the kitchen table, the pencil, the columns of figures, the confirmation that I know where I stand. Here is what is actually true, and I want to say it without simplification. Documentation is not defense. It is not the habit of a suspicious person or a person who expects to be wronged. It is the habit of a person who understands that what you own exists in 2 registers simultaneously, the register of your own knowledge and the register of what can be demonstrated to someone who does not already know. Those 2 registers are not always the same. The gap between them, between what you know you have and what you can prove you have, is where loss lives. Close the gap every time. Not because something is about to go wrong, but because closing the gap is what it means to take seriously the things you have built. The second thing is about asset structure, and it applies to anyone building anything that generates value. An LLC is not a complicated instrument. Registering an LLC with the Georgia Secretary of State costs $75 at the time of filing and requires a name, a registered agent, and a 1-page Articles of Organization form available on the Secretary of State's website. The operating agreement is a separate document, typically prepared with an attorney for a few $100s, that defines who owns what and in what proportion. Once formed, an LLC creates a legal boundary between its assets and any personal claim against its members, and critically between its assets and the marital estate of its members, provided the LLC is formed before the marriage, maintained with operational separateness, and never commingled with marital funds. The boundary is only as strong as the documentation that demonstrates it. But if the documentation is clean, if the LLC's accounts never touch joint accounts, if no marital income ever funds an LLC acquisition, if every deed names the LLC and only the LLC, the boundary holds against exactly the kind of claim that was advanced in a courtroom on Pryor Street in 2021 and abandoned 40 minutes into a recess. The third thing is about the timing of protection. I did not protect the portfolio after the marriage began to deteriorate. I did not call Adiz after Marcus said the portfolio on a Tuesday evening in January of 2020. I called her then to confirm that the protection already in place was sufficient and to begin the formal legal process, but the protection itself had been built continuously as ordinary operational practice since 2011. You cannot install documentation retroactively. You cannot create a 9-year record of clean separation at the moment you suddenly need one. The record is either there in the binder, in the bank statements, in the court's own file, or it is not. If it is there, it is simply the history of how you ran your affairs. If it is not there, what fills the gap is narrative, and narrative in a legal proceeding belongs to whoever tells it more persuasively. I had no interest in a narrative contest. I had a binder. The fourth thing is about the mothers who kept the records first. My mother is not a lawyer. She is not a financial advisor. She has never held a professional credential in any field adjacent to asset management or legal documentation. She is a woman who understood, from some combination of necessity and intelligence and the particular wisdom that comes from managing a household on limited resources without margin for error, that the family's position in the world had to be knowable at any moment, to any person who needed to know it, from a single document kept in a cabinet beside the stove. She applied to her household the same rigor I later applied to an LLC with 8 properties. The rigor is not complicated. It does not require professional training or advanced education or significant resources. It requires only the willingness to treat the facts of your own financial life as things worth tracking, proving, and protecting, not when something is about to go wrong, but always as a form of basic respect for the things you have built and earned and own. Everything you own should be findable in under 3 minutes. If you cannot prove you have it, assume someone will eventually claim you don't. I signed those divorce papers without a fight because I had already won. Not in a courtroom, not in a negotiation, not in the 40-minute recess while opposing counsel reviewed a 9-year-old operating agreement on file with the court's own clerk. I had won in a property records office on a Wednesday afternoon in February of 2018, when I paid $47 to record a deed and wrote the entry in the binder that evening. Deed book 56,782, page 214. I had won every Sunday evening for 9 years when I updated the log and filed the statement and closed the tab. I had won every time I opened a new property file and placed it in a labeled tab before the ink on the deed was dry. The judge opened the file. The file said what the record had always said. There was nothing left to fight about. There never had been.